Are we good? Okay. I think we're going to go ahead and get started. We've got one of our panelists is running a little bit late, but I think we'll be okay, and we'll slot him in here when he gets here. I want to welcome everybody. My name is John Nalbandian. I'm a judge on the Sixth Circuit, and the title of this panel today is A New Approach to Antitrust Law, Transparency. As many of you are aware, antitrust law has seemingly come back into vogue, at least in some circles, in light of the recent FTC hearings and ongoing hearings on competition and consumer protection in the 21st century, and renewed publicity in generalist publications like the New York Times and The Economist, with a particular focus these days on the so-called FANG companies, Facebook, Apple, Amazon, Netflix, and Google. I have to confess, however, that much of this is new to me. My antitrust experience as a private practitioner and as a one-time summer intern in the antitrust division was firmly rooted in traditional markets for goods and services and basic good old horizontal conspiracies and price fixing. Indeed, a day when lower prices were actually a good thing. I was what you might say, or what I call myself, a widget antitrust lawyer. Now, these days, at least, it seems as if many people are calling for a reinvigoration of traditional antitrust law, and also, in fact, for new concepts of antitrust law that will carry even more weight to address perceived problems with things like labor markets and wages, income inequality, privacy, and naturally, because Godwin's law apparently has no bound, to prevent the rise of fascism itself. Although I expect that our panelists may touch on some of these broader themes, our focus today is a little more narrow. Our panelists are specifically going to address the role or possible role of greater transparency in the implementation and enforcement of antitrust laws, something that arguably Europe and the EU have been doing a better job of than we have. One question here is whether greater transparency, combined perhaps with current law, is a better way to incrementally address calls for the greater reform and use of antitrust laws, perhaps a scalpel on a tray of otherwise blunt instruments. Federalist Society panels, of course, are well known for their quality, and this one is no exception. And I will introduce our panelists briefly, and then they will each give opening remarks, and then hopefully we can have some back and forth, and then obviously we'll take questions from the audience. Our first speaker is Deb Garza, who is a partner at Covington and Burling, where she co-chairs the firm's Global Antitrust and Competition Law Practice Group. Ms. Garza has extensive antitrust experience, which includes, in addition to her current work in private practice, past service in the Department of Justice's Antitrust Division as an acting assistant AG, deputy assistant AG, and chief of staff and counselor to the assistant AG. And she will chair, or perhaps is currently chairing, the antitrust section of the ABA during the 2018-19 year. Next, we have Eric Grannon, a partner at White & Case, where he has built an impressive practice focused on helping clients with antitrust matters, including both civil and criminal defense. And I believe Eric is going to talk to us a little bit about the criminal aspects of antitrust, as well as his work counseling for mergers and acquisitions and settlements of pharmaceutical patent litigation. A former prosecutor, Mr. Grannon also served as counsel to the Assistant Attorney General in charge of the Antitrust Division during 2003-2004, where he helped formulate U.S. antitrust enforcement policy and manage the civil and criminal investigations and court cases brought by the Antitrust Division. To my left, To my left here is Judge Frank Easterbrook, who is, of course, a familiar face to the Federalist Society. Judge Easterbrook serves as a circuit judge on the Seventh Circuit, where he served as chief judge from 2006 to 2013. He is also a senior lecturer at the University of Chicago's Law School. Before joining the court in 1985, he was a professor at the University of Chicago, where he taught, wrote, and published prolifically in a variety of areas, including antitrust, securities, and corporate law. In addition, Judge Easterbrook was previously served as Deputy Solicitor General of the United States. Finally, we have an empty chair that will be hopefully Professor Douglas Melamed from the Stanford Law School, where his principal areas of research and writing are antitrust law and the intersection of antitrust and patent law. Prior to joining the Stanford faculty, Professor Melamed practiced law for 40 years, including serving as Senior Vice President and General Counsel of Intel Corporation, Chair of the Antitrust and Competition Practice Group as a partner at WilmerHale, and service at the Department of Justice as the Acting Assistant Attorney General in charge of the Antitrust Division and as Principal Deputy Assistant Attorney General. So please help me welcome our panelists. And thank you. And I'll turn it over to Ms. Garza.
Okay, great, thanks. So if the question is transparency, to me the answer is yes. I want it now and I want it fast. When I talk about transparency, I'm talking about transparency in antitrust investigations and enforcement. And not so much what transparency, of course, is relevant to U.S. enforcement. It has been particularly relevant for jurisdictions outside the U.S. In the past, in particular in Europe, but also in Asia and in newly emerging jurisdictions that don't have as well-established rule of law as do we, or that have different systems of administering antitrust that don't involve the courts. So it's been a major objective of the U.S. government and the antitrust community to promote transparency for many years. It's been a bipartisan effort, and it's continued through this administration. So I thought I would talk in my opening remarks very briefly about what we mean by transparency, why we value it, where it becomes an issue, and then a little bit about what some of the efforts are that are going on now to try to ensure and promote transparency, several of which I've been personally involved in. So the benefits of transparency are really many. For one thing, it's necessary for the free flow of capital and investment because you need certainty and you need predictability. And transparency in the rules that are applied and how they're applying it, both in the investigation context and the enforcement context, is critical to businesses in planning transactions to do that. It's important to efficient enforcement. It's important to maximum compliance. Companies are better able to comply with the law, whether it's in structuring their transactions in a way that will be approved or determining what their conduct will be. Transparency allows them to conform their behavior more closely to the law. It allows for efficient enforcement as well if people know what the standards are. But two, also, because as I'll get to, transparency enables the agencies to be better informed about the decision-making process. Transparency is good for accountability. If you are transparent about the rules that you applied, the procedural rules and the substantive rules, then you can be held accountable. And we want our enforcers to be accountable. It's important to confidence in enforcement. It's important that people understand, the antitrust community and others understand what the rules are, how they're applied, that they're applied impartially. It protects against corruption. It protects against special interest capture. It protects against capriciousness and just plain bad decision-making. It protects against impartial enforcement, which is something that has been a big concern for the business community, particularly in jurisdictions like China, but in other jurisdictions where you can never be sure whether the action that's being taken is based on complaints by competitors or national champions. It can be situational or it can be systematic. And the way to ensure transparency, I think that there are numbers of ways to do it. One is by requiring by agencies being, as I said, clear about what the standards are that they're applying through the issuance of guidelines, through written case law, through statements, policy statements, by articulating what their decisions are and how they went about it. It's transparency with the parties that are subject to investigations, letting parties know when an investigation has been opened, what the basis of the investigation is, what the allegations are, in some sense what the evidence against them is, all of which allows parties obviously to better defend themselves and actually enables the agencies to get evidence and information that will enable them to make smarter decisions. So those are some of the, I mean, there were more reasons why, but that's why we value transparency. But let me just tell you a little bit about a number of the efforts that are going on by international, multinational organizations. One is the OECD, the Organization of Economic Cooperation and Development, I think that's what it stands for. In June of 2018, and I should say that the thing I'm going to talk about that the OECD is doing is really prompted by the US as a champion of this. But in June of 2018, the OECD issued a scoping note, and the OECD committee that looks at competition law issued a scoping note on transparency and procedural fairness as a long-term theme for 2019 to 2020. That's the title, and it's actually pretty important because the U.S. has been trying to get the OECD to do exactly that, which is to focus on transparency as a long-term theme. And part of the rationale for the scoping document and for the work that the OECD will be doing is a belief that transparent and fair process helps to ensure the impartial and reasonable treatment of subjects, and at the same time helps to improve the quality, accuracy, and comprehensiveness of analysis and decisions. So that's one effort, the OECD. The ICN, which is the International Competition Network, which is an organization of almost all of the national competition authorities around the world. It's a informal organization of these countries to exchange best practices and talk. And there is a document called the Competition Agency Transparency Practices Document, which is part of the Agency Effectiveness Project. And that, too, is about urging all competition authorities to adopt practices, not just transparency, a whole host of processes that are aimed at preserving due process, but that include transparency. The ABA section of antitrust law, I know the ABA isn't very popular among everybody at FEDSOC, and I'm not so wild about some of the ABA activities myself, but I am the chair of the antitrust section. And we have done two things in this area. One, there is an international task force that has adopted best practices for antitrust procedures. That includes a number of things, including transparency. But probably more important than that, we have an international procedural transparency task force. This task force was established to study and report on implementation. So they have been basically talking to folks around the world, talking to the business community and others in the antitrust community to see to what extent if people have competition agencies actually implemented these best practices, and where they haven't, to kind of name and shame them. Another thing that I've been involved in that Deb Melamed was also involved in with me is the International Competition Policy Expert Group, which came about when the U.S. Chamber of Commerce invited a bipartisan group of competition and trade law experts to make recommendations to the then incoming president and Congress about how to align trade and competition law. And one of the things that we did recommend was to take action to promote transparency. The real issue for that group was that we have lots of guidelines and suggestions about transparency and other elements of due process, but we really don't have any enforcement mechanism. And so we focused on what the administration could do to actually make this concrete. And some of our recommendations were to try to expand the World Trade Organization, the WTO's regular assessment of members by the Trade Policy Review Group to expressly include an analysis of how well they're doing in terms of due process, including transparency. Another thing that we recommended was that the OECD be encouraged to do specific peer reviews of participating countries and specifically focusing on their processes and whether they provide transparency. And a third was to encourage the OECD to adopt a code that would enumerate transparent and impartial procedures. And finally, I want to talk about what the current administration is doing. Makin Delrahim, as the Assistant Attorney General for Antitrust at the Department of Justice, has adopted something that's called the MFP, which is the Multilateral Framework on Procedures in Competition Law, Investigations and Enforcement, much easier to say MFP. And his objective, and which I like to think follows a little bit on the recommendations of the, on our policy expert group, was to try to ensure meaningful compliance with standards beyond the suggestions and guidelines and recommendations. And the theory that they were working on, and again, this goes beyond transparency, but transparency is part of it. The theory they were working on is that you can obtain compliance in one of three ways: by threats of retaliation, by promises of reciprocity, and by potential harm to reputation. And the MFP is really focused on the reputational part of it. So he's been going around the world trying to get people to sign on to this procedural framework with the idea of tying it to your reputation as an agency for providing these protections, including transparency. And finally, I will say that some of the competition chapters in the free trade agreements have included and are increasingly including references to due process, including transparency. And I know it's not called NAFTA 2.0. I've forgotten what it's called, but NAFTA 2.0 and the Korean Free Trade Agreement both include chapters that have pretty good provisions on transparency.
Okay. Yeah, I'm going to stand in the hope that this light won't be directly in my eye. I actually feel like I'm going to confess to an antitrust crime or something up here, so hopefully that won't happen. So good afternoon. I'm Eric Grannon. I'm going to focus on some transparency issues in the DOJ Antitrust Division's criminal enforcement program. And my first suggestion is quick and mostly symbolic, but I think nonetheless important. The division should put the briefs for both sides of its litigated cases in criminal matters and civil matters up on the division's website. The division is not just another litigant, it's the government, and with that special role comes the special responsibility of keeping the public fully informed about the division's cases, and putting up only the division's briefs for the public to see does not live up to that responsibility. Second, the division needs to rethink what I call the batting average mentality for criminal antitrust enforcement that's applied for about the last 20 years. Each year, the division reports on its criminal enforcement activity, and it seems like the division is only happy if it can report ever-increasing totals of fines and annual jail time obtained. Now, I think that may have made sense for the first 10 or 15 years of the amnesty program, but we're now in the 25th anniversary of the amnesty program. We've succeeded not just in exporting antitrust and competition law all over the world, but almost every major jurisdiction follows our amnesty and leniency paradigm, even if the penalties are only civil or administrative rather than criminal. So in reality, the whole world has drunk our Kool-Aid when it comes to competition enforcement, and to boot, all of these enforcers around the world are now cooperating together in enforcement, which is something that Deb alluded to. The enforcement network has never been stronger. As a result, companies operating in Europe, Asia, and developing parts of the world are internalizing the same cultures of competition compliance that have been strong in the United States for close to 100 years. Now, if we've done all of that, folks, and we don't start to see a decline in cartel activity, then something is very wrong. Now, the division is always going to report on fines and jail time, which is appropriate for a public agency. But what I'm suggesting is that the headlines, if you will, of division reports, the focal points of division speeches might benefit from some new metrics. So, for example, the division has 50 or 60 PhD economists. They could start headlining the millions, if not billions of dollars consumers are saved as a result of division prosecutions. The division could use its international DAG as an ambassador to top-tier companies throughout Asia, for example, and report on how many of those companies have adopted what we would consider to be gold star antitrust training and compliance programs. Now, these are just a couple of examples, and I'm sure there are other meaningful metrics for success beyond fines and jail time. Third, the division should reassess Amnesty Plus, and in particular, its implications for follow-on class actions in the United States. So I'm going to give a little background for this. Amnesty Plus applies in this scenario. My company has been fingered by an amnesty applicant in, let's say, the widget industry, for example. And I agree that my company will plead guilty, pay a substantial fine, and agree that some number of my executives will be carved out of the company's plea agreement and prosecuted for having price-fixed widgets. I then get to say, oh, Mr. or Ms. Division Prosecutor, while you're prosecuting me for widgets, I want to tell you about another cartel I'm involved in the sprockets industry, for example. Now, if I convince you, I then become the Amnesty Plus applicant on sprockets, which means I get a complete pass from prosecution for my company and our executives on sprockets, but additionally, I get a substantial discount on my corporate fine for the original widget conspiracy. Now, you can imagine the incentives that creates for companies to come up with conduct that will effectively injure other industry participants. And the division has reported in recent years that more than half of its prosecutions are coming from Amnesty Plus applications, more than half. Now, my concern on this is not at all hypothetical. I've worked defending a company that was a target of an Amnesty Plus investigation. After granting Amnesty Plus, however, the division never indicted anyone and obtained no guilty pleas. That means the Amnesty Plus had been improvidently granted in the first instance because it's only supposed to apply to hardcore cartel conduct. Now, you might ask, so what? Your client, never got prosecuted. It had the hassle of a criminal investigation, but no harm, no foul, right? Wrong. The rub is that as soon as the grand jury investigation starts for the Amnesty Plus industry, like night follows day, here come the treble damage class action cases. And because of the interim threat of treble damage jury trials, and not to mention the expensive, drawn-out nature of antitrust litigation and discovery in particular, many companies end up settling non-meritorious claims. And I can say specifically that in that investigation and the follow-on class actions I'm referring to, several companies paid settlements in the tens of millions of dollars as a result of the division's grant of Amnesty Plus, but where no company or individual was ever prosecuted. The division should announce a public workshop on Amnesty Plus, including its civil litigation implications, schedule the workshop for sometime in mid-2019, and use the intervening months to solicit speakers and papers from prominent practitioners, economists, and academics. And most importantly, go into that kind of public workshop with an open mind rather than seeking justification for current practices. Fourth, it's time for an honest determination of whether antitrust offenses constitute crimes involving moral turpitude. The division's prosecutions of individuals are overwhelmingly of non-US nationals, almost all of whom have pleaded guilty rather than been convicted at trial. Now, one reason for all the guilty pleas is that the division leverages a 1996 MOU with the former INS, now ICE, that, quote, considers antitrust offenses to be crimes involving moral turpitude. Now, the consequence of that MOU, which has no valid legal authority whatsoever, is that any foreign national convicted under the Sherman Act can thereafter be excluded from the United States for up to 20 years. Now, that's a career killer for a lot of non-US business people. But the division generously says, if you plead guilty, rather than go to trial, we will waive the application of our MOU that we made up. Then you can serve your 2 or 3 years in one of our comfy minimum security prisons and travel freely to the United States once you're done serving your time. Now, I've researched on this, folks. I've published on this issue. My article is in your CLE materials, and there is no precedent whatsoever for antitrust offenses to be considered crimes involving moral turpitude, which is a category of depraved crimes, most of which existed at common law. The division should publicly commission an independent legal opinion from the Office of Legal Policy on whether antitrust offenses constitute crimes involving moral turpitude, and let the chips fall where they may based on OLP's published opinion. My final point is that career division prosecutors should not be the only candidates for the criminal DAG position in the front office. The AAG in charge of the antitrust division is a presidential appointee, and all of the other DAGs historically have turned over with each new administration. We have 93 U.S. attorneys across the country who dole out much larger sentences than available under the Sherman Act, and those U.S. attorneys all turn over with each administration, and the republic is still standing. The division's criminal DAG should also be a political appointee. Now, this is not a job application on my part, by the way, but it should be someone who can bring the perspective of both criminal and civil antitrust defense from the private sector, and someone who won't be beholden to the views and practices of the career staff. I think that perspective might help mitigate some of this overreaching and lack of transparency that at least I've addressed. So with that, I think I'll hit pause and look forward to any questions or comments you all have.
Thank you. The premise of this panel is that antitrust enforcement needs change. If not something substantive, then more transparency. I'm here as the stick in the mud. I agree with Edmund Burke. Don't talk to me of reform. Things are bad enough as they are. Antitrust law does not need new enforcement or new objectives. It should not be invoked to improve the environment or promote racial justice or help small businesses. It needs accurate enforcement to better the lot of consumers, which is its goal. Other statutes have different goals. Trying to load multiple goals into one law produces a muddle. And you're bound to get less of the main objective, competition that drives prices toward marginal cost. More litigation doesn't promote better enforcement. Antitrust helps consumers when used properly, but it's also an attractive nuisance. Litigation provides a means for firms to raise their rivals' costs. Even the threat of litigation is costly. It also helps politicians strike at out-of-state or otherwise unpopular producers. Used that way, antitrust can become a tool to stifle competition and harm consumers. Chicago's prescription, also the prescription of this man, this is my Adam Smith tie, is to bust cartels and prevent mergers to monopoly. Open up markets, domestic and international. Reduce regulation. Let competition do its job. If we had data showing that consumers lose from other things, and if we could be confident that judges could reliably find those other things, then by all means expand the portfolio of antitrust. But there are no such data, and there's no reason to believe that judges whose principal portfolio in life is managing cocaine prosecutions are very good at economic managers. We've been asked to talk about transparency, which sounds like a goal of window design rather than a legal regimen. True, it's become a catchphrase. Everyone is for it. But what is it? Transparency is very trendy in Europe, which leads me to worry that it's a code word for a European fair competition model. In other words, be kind to one's rivals. That doesn't help consumers. The goal of competition is to hurt rivals, as Joseph Schumpeter put it, to be a gale of creative destruction. Anything providing comfort to producers will harm consumers by keeping the inefficient in business. Perhaps transparency is something producers offer each other. Complete statements of their prices and sales or how they make their products. We've seen that before. The usual understanding in antitrust circles is that transparency at the industry level is a cartel-promoting device. If everyone can see what everyone else is charging and to whom everyone else is selling and how much, it becomes easier to coordinate prices and output. Secrecy, by contrast, is the enemy of cartels because it becomes possible to cheat on the cartel price without being caught. So we ought to oppose transparency for producers. Perhaps, though, transparency means openness at the enforcement level when deciding what cases to bring. I'm skeptical of that understanding, too. Prosecutors need a deliberative process privilege and the ability to offer confidentiality to informants and potential witnesses. Ordinary criminal prosecutors don't announce what cases they are considering and how they decide among them. To the contrary, both state and federal systems have powerful rules of grand jury secrecy that not only protect the interests of persons who are considered but ultimately not charged, but also improve the ability of prosecutors to make decisions free from political influence. The guidelines issued by the FTC and the Department of Justice afford some general notice, but they're explicit that they don't bind either the enforcers or the courts. Otherwise, they would offer opportunities for business planning. In tax law, those opportunities are generally referred to as loopholes. But loopholes go with any detailed system of regulation. They inhere in systems of detailed rules. And I don't think they should spread to antitrust in the name of transparency. More than that, transparency interferes with James Madison's prescription for good government. This guy, Madison, his essay, known today as Federalist number 10, contends that the power of faction, what we today call interest groups, can be diminished by breaking government into smaller segments with different constituencies and by making creative use of silence. In modern language, he argued that civic-minded representatives need agency space to do their work. If they are always being monitored, all they can do is react to the demands of factions, which all of the framers agreed were baleful. Factions in the antitrust world consist of producers who are always trying to find ways to compete less and charge more. We need to do more to insulate enforcers from them rather than make enforcers more readily controllable through political pressure. And it's transparency that gives producers the time to bring political pressure to bear on enforcers. This is a long-standing problem in American law. The Administrative Procedure Act of 1946 requires agencies to publish detailed proposals, then wait for comments. That exposes the whole administrative process to the power of faction. The Administrative Procedure Act was sold in the name of transparency. You could see what your government is doing, but the result has been to magnify the power of interest groups. In 1946, people thought that rules could be adopted under the APA's procedure in a month. Now they take years, sometimes decades, because interest groups tie up the process in knots while bending it to their own ends. A vital feature of independent agencies, such as the FTC, is not the tenure of its members, but their isolation from the rest of the executive branch. A president can resist claims by interest groups in the way Madison envisaged, by adding other items to the agenda. But agencies devoted to single purposes, like antitrust, lack threats. They can't promise to veto Bill X in response if some committee in Congress or interest group takes step Y. The absence of log rolling means that factions in committees in Congress have extra influence. More to the point, that power has been transferred from the president with a national constituency to commissioners and committee chairmen who have different constituency and are less responsive to the public as a whole. Even the Antitrust Division has a limited agenda, which makes it hard to control the threat of factions and their legislative supporters. More transparency makes this problem of control even harder. The Administrative Procedure Act, the Freedom of Information Act, the Government in the Sunshine Act, and extensive provisions for judicial review all ensure that interest groups have many points of access and influence. They monitor intensively. Insulation from their influence has become an objection to the behavior of public officials, and that's what we hear in the name of more transparency. Failing to wait for group monitoring and input is seen as a bad thing, rather than, as Madison argued, a good thing. From a public choice perspective, it can be no surprise that those members of Congress with the most seniority vigorously resist presidential efforts to coordinate public policy. So I urge you to resist the call of transparency, no matter how much extra sunshine seems beneficial. Always remember that sunlight is full of ultraviolet radiation. And our goal is not to have more in the abstract, but to have the right amount and always carry a bottle of sunscreen. Thank you very much. Now, before I sit down, I should say that I've talked to Professor Melamed. We're sorry he isn't here, but he told me to say that his whole talk would be what it was that Judge Easterbrook just said. That's exactly right. Thank you very much.
So do I get to respond?
Yeah, it looks like we aren't going to have Professor Melamed, so why don't we go ahead with panelists who want to comment?
I do. So look, I don't disagree with everything that Judge Easterbrook said, but I want your telephone number, because the first time that I sit across from someone at the Chinese Competition Authority who wants to explain to me why they think it's appropriate to operate behind a veil of secrecy, they tell me it's because Judge Easterbrook urged me to resist the call for transparency. I think as a practical matter, it may not resonate as much with us in the US, because we understand that our antitrust enforcers ultimately have to go to a court of law to stop a transaction, to punish a cartel, to punish other anti-competitive activity. But we live in a world where everybody has, almost everybody has a competition law regime, and not everybody has the kind of systems that we have. Not everybody has guarantees. Not everybody, in some cases, the prosecutor is the court. And in other cases, there isn't a well-established rule of law. So, we've seen situations in China, for example, where companies do not know what rules are being applied to them, do not know what evidence is being provided to the enforcers, do not know what is deciding the future of their transaction or their ability to keep doing business or to prevent their intellectual property from being expropriated. And that's a problem. That's a problem if we want to live in a world with free trade. It's an issue for a lot of my clients that happen to be companies that engage in mergers and acquisitions. I happen to think it's a good thing to have a free flow of capital, in the cross borders included. Companies can't make decisions about transactions and the risks, et cetera, if they don't know what the rules are. If there's no transparency into how the various competition authorities around the world are going to look at their transaction, if they don't know how they define relevant markets, if they don't know what the standards are, if they don't know what the rules are in terms of divestitures and fixes, if they don't know what the timelines are. So there's a lot of, to me, there is a lot of good to transparency if you think that markets function most efficiently, when people are aware of what the rules of the road are, when they can be assured that the rule of law will be applied to them. I think it's a good thing. Eric mentioned the criminal context. It's also important there. So you're the subject of a criminal investigation. You have no idea. Obviously, there are going to be some. Transparency doesn't mean standing naked, right? So there's going to be some things that you're going to not do. You're not going to breach privilege. You're not necessarily going to reveal all confidential sources. But Companies that are being criminally prosecuted have the right to know for what? Basically for what? What are you looking at me for? What are the relevant products? What's your key evidence? Otherwise, you can't defend yourself. Otherwise, if we don't have that kind of fundamental basic transparency, you cannot be sure that you're getting impartial treatment. You cannot be sure that there's no corruption. You cannot be sure that there's no political influence. You cannot be sure that you'll be able to defend yourself. And there's no accountability at all for the enforcers. And I've been on the other side as an enforcer, and I believe in the integrity of our enforcers, but I also know that it's a hell of a lot easier to do your job if you never have to explain it. If you never have guidelines that you know that you've put out that you have to explain to people that you're following, if you never have to prove your case. I mean, it's a lot easier, certainly. It's a lot easier to get lazy. So I actually do think that transparency is essential to protecting individual rights. It's essential to allowing for the free flow of capital. It's essential for a rule of law. And so I say put your sunscreen on and go forth. I think we need to ensure that the rest of the world provides transparency, and we need to keep doing that here in the U.S.
Deb, can I ask you a question, just a little bit more concrete? Are you suggesting that there needs to be more formal statements in the context, let's say in civil context, in the context of individual mergers where the government is explaining why or why not they approved it? Or are you talking also about, are you looking for more or broader guidelines, policy statements, in more, I guess, formalized, broad-based statements, or are you looking at kind of more granular things?
Well, so most of my efforts have actually been focused outside the U.S. Inside the U.S., the issue for people has been guidelines, and frankly, guidelines that are relevant. So, for example, today we have vertical merger guidelines that actually were adopted in 1984 that are no longer really instructive, but we have significant enforcement matters on vertical theories, like the AT&T Time Warner theory. Frankly, that's probably a very good example of how current vertical merger guidelines would have been a help. Because I do think that the Antitrust Division had a legitimate basis to challenge that transaction. It was the same basis that they challenged Comcast NBCU. They have a different view of the efficacy of consent decrees, but there was a lot of finger-pointing in that case, people claiming that the reason that the Antitrust Division brought that case had nothing to do with legitimate antitrust concerns and were more driven by the views of the president and his supposed animosity towards CNN. Had the division had in place merger guidelines that they could have pointed to, I think they could have resisted more that kind of finger pointing, because it would have been clear the kinds of evidence that they looked at and the theories that they were following, and it would have been much more clear that this case was not aberrational, but it was consistent with their own guidelines. So that's an example where the guidance would have been helpful, frankly, to maintaining confidence in the enforcement. I will say there is a bit of a difference, and there has been discussion in the U.S. about the degree to which you explain enforcement matters. So in the U.S., obviously, if you challenge a transaction, either you have to go to court and prove your allegations, and when you go to court, you reveal your theories and your evidence, et cetera, or you settle the case with the parties, in which case you do provide some explanation of, again, what your theories are, some of what the evidence is, why you think the remedy is sufficient, because you have to do that under the Tunney Act. If you don't challenge a transaction, most of the time there isn't an explanation in the U.S. In some cases there has been, both when I was at the Antitrust Division and the FTC has done that, where there was a potential public expectation that a transaction would be challenged and it wasn't, then there have been short statements explaining that. I can think of one instance being SiriusXM, where the Antitrust Division did not challenge, and so we issued a statement so that people would understand why not. And again, the reason we did that was to try to maintain confidence in our system. In Europe, and this may be why you said, and I generally don't agree that Europe is better on transparency than we are in the US, but in Europe, they issue some kind of statement with respect to every transaction they look at, including if they don't challenge it. So there's a somewhat more transparency there. And I do think that there are downsides to issuing statements even when you don't challenge a transaction, because it does tend to set a precedent and bind you in a way when you maybe haven't, it binds you in the future, and that has both upside and downside, but on balance, I think there are some reasons why you wouldn't necessarily want to adopt the European style here.
There has been some suggestion that if a merger is not challenged, and let's say there's a certain threshold, the company is $1 billion in market cap or has 1,000 or more employees, and it's not challenged, that the FTC or DOJ should explain why they didn't, and in fact solicit public comment on that merger. Is that something that?
I don't think that that's a great idea, but there also have been calls that said if you engage in a what we call a second request, if you engage in a second request examination, which is which is usually a 3 to 6 to 9 month investigation, and then you close without challenging, that you should give some explanation. And I mean, I think there's some basis for that. I don't think you want to open it up to public comment, but I will say that the Antitrust Division and the Federal Trade Commission, when they look at transactions, they don't ask for public comments, but they do reach out to suppliers, to consumers, to business partners. So there is some collection of evidence from people, but not a general a request for comment. I don't think that would be very fruitful.
Do you, Professor Melamed, would you like to give your remarks, or?
Well, I'll say just a couple things. First, apologize for being late. I actually had this on my calendar for tomorrow until I got a text a few minutes ago. Well, I have an excuse, but I won't bore you with all that. I just wanted to say, and I hope this isn't completely out of context here, the topic, initially at least, was framed in terms of the role of transparency as an antidote to some of the unrest about competition law, the populist movement and all of that. And my reaction was basically that I think that misdiagnosis is the problem. That the problem, I think, from the critics' perspective is not that they don't understand antitrust law, although I think they often don't, but they perceive outcomes that are worrisome to them, increase of industrial concentration or economic power, wealth distribution, whatever. I don't think that greater transparency about how antitrust works is going to answer their concern that, well, these problems are still happening in the world. So I think what's needed is a substantive engagement on the question of whether these are real problems, and if so, whether intervention by the government's called for. Antitrust guidelines and closing statements and all that seems to me are largely beside the point. That was just a basic point I wanted to start with.
Let me ask you this, Professor Melamed, because I know you've written about kind of the responding to the criticisms of the existing consumer welfare paradigm, and the idea that actually the consumer welfare paradigm might be a little bit more flexible than we give it credit for, right? That it does deal with more than pricing. Why isn't it that greater transparency wouldn't be a part of working within that paradigm to kind of address whatever these perceived issues are? Or are you just completely rejecting that there are any problems right now?
No, I'm not rejecting there are any problems. I think, yes, I'm not saying when I say transparency is not a problem, I'm not saying we should not engage in conversation with the critics and attempt to disabuse them of some of their concerns. I think to those who articulate the concern in the form of an argument that says we should abandon the consumer welfare standard in antitrust and move on to some more populist, new brandeized, multifaceted set of criteria. I think as to them, yes, we should respond, at least to the extent, and the response I've made in a couple of papers does say, among other things, many of the criticisms you make of the consumer welfare standard, it focuses only on price, it ignores innovation, and so forth, are simply wrong and reflect a misunderstanding of the consumer welfare standard. But ultimately, I don't think that's going to end the debate, because it will just, I think it will cause the debate to be focused, probably where it should be focused, on the larger political economy question of, do we have issues of concentration of economic power and wealth in this country that ought to be addressed by some form of government policy.
Judge Easterbrook, I don't know whether you had a response to what Deb said before Professor Melamed came in. I'm imagining that, well, let me ask you, what's wrong with more guidelines or policy statements or fair notice to criminal defendants?
As I said in my opening remarks, part of the problem is that transparency has become a word that doesn't have that much content. It is being used for all good things. The proposition that the law should be knowable, judicial opinion should be accessible, was a proposition that was embraced when this country was created in the 1780s. It was thought to be absolutely essential. It was long before anybody invented the word transparency. So if the problem with foreign antitrust enforcement is that nobody knows, that producers and consumers don't know what they are supposed to be doing, even approximately, that's a serious problem. But dealing with it is not, the word transparency doesn't describe how you deal with it. After the Sherman Antitrust Act was passed in 1890, I think it's fair to say that very few people knew what it was or what it did. Judge Taft on the Sixth Circuit writes the first great opinion in Addiston Pipe and Steel and begins to give content to it. That content is expanded through the decades, and we now have a very good idea what antitrust did. That was all achieved without resort to transparency. The concern I was expressing, particularly about Madison's concern, is making the process of antitrust enforcement more open to the influence of interest groups. That, it seemed to me, was one that will do harm to consumers. And that's not something that Deb Garza dealt with in response to my comments. So I'm, in addition to worrying about the access of interest groups to enforcement policy, I'm also worried just about loading too many things into one word, because then it's very hard to have a conversation about whether that word is good or bad.
Eric, did you have a comment?
Yeah, just briefly, I guess in thinking about this idea about transparency being potentially bad, there's a whole other side to this also, which is antitrust lawyers play a very important role in counseling clients on how to conduct their businesses. And if you're in your role as a counselor, you don't have good visibility into how decisions will be made and what type of analysis will be followed by the enforcers, then your role as a counselor is really handicapped quite poorly. I think, respectfully, a lot of Judge Easterbrook's comments assume the kind of safety valve that we have in the United States, and that makes sense, of 100 years of common law development of antitrust principles, as well as sort of the safety valve of federal courts for relief. So I'll just give an example. My firm just recently won a price-fixing jury trial against the Antitrust Division in the Southern District of New York in the area of foreign exchange, the alleged foreign exchange manipulation. The division gave our team access to some pretty important file materials, including interview notes, the Friday before the trial was to begin on Monday. So I guess I would challenge Judge Easterbrook or anybody who says that that is a good thing. I don't think James Madison would agree with that. But nonetheless, we had the backstop of federal courts, and we won that case. Had we been in a different jurisdiction, had we been in Europe, or had we been in China, the prosecutor is also then acting as the fact finder. And I think those types of failures of transparency can then have all kinds of even greater concerns. So I guess that would be my one brief response to that.
Let me ask you, and we'll open it up to audience questions here in a second, but let me ask you, Eric, you had a lot of suggestions and some points about what maybe we're doing wrong in the area of criminal enforcement. I'm curious whether you have some thoughts on what we're doing right, and if there are things that are maybe a model for the rest of the world, or whether we're at least we're on the right track on some things. Can you talk about that maybe?
Yeah, I guess I can address that briefly and say that we certainly deserve credit, as I said, for exporting antitrust around the world, for exporting the efficacy of the amnesty model, which is the greatest deterrent to cartel activity, is to provide incentives to companies to report themselves. I am also a very firm believer that criminal penalties, meaning jail time for individuals, is the greatest single deterrent to anti-competitive conduct. So, for example, in Europe, they have really, 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 really big fines, but that's not the same thing as an individual having to face the prospect of up to 10 years in prison. So I'm a believer in our criminal enforcement system. I guess where my comments were going were more along the lines of, having worked there, I saw this. That was 15 years ago, but I don't think that the division needs to be apologetic at all, or have an apologetic attitude about the number of total months in jail they obtain against defendants going down, or fines going down. I think that is a consequence of our success. So that's what more of my comments are about. There's plenty of things that I think we do right. There are other things that need to be worked out along the way. Like for several years, I mentioned these carve-outs. Well, what would happen is the division would publish the names of the carved-out individuals. So here's a corporate plea agreement for widgets, and Acme Company pleads guilty to widgets, and then here are 6 or 7 executives that are then carved out for prosecution. Those names are out there for everyone to see. Those individuals' reputations are severely impacted by that, and in many innumerable investigations, those individuals were never prosecuted. No indictment, no plea agreement, but their names were nonetheless published. Now, it took about, 7 or 8 years before that finally trickled up to the front office to stop doing that, and now they don't do that any longer. That's a positive step. But many people had their careers and their families, their personal lives severely impacted by this practice. And those of us in the antitrust defense bar raised that issue. And it again, we got the correct outcome, but it shouldn't have taken as long as it did. And many people suffered under that policy. So that's the kind of thing that I think we need to be more responsive to. And I can tell you, I say this with all due respect, but the comments I made about the amnesty plus regime and how that works, that's anathema to so many people at the antitrust division. How dare you question, this model that we have that garners more than 50% of our prosecutions? Well, because there's problems with it. And when you give amnesty plus in an industry and you never prosecute it, you never indict anyone, and you never get a plea agreement, that means you did something wrong. So that's where my comments were going about why, much like the other U.S. attorneys all over the country, I think we should have a politically appointed criminal DAG who could be a little more distant and maybe not so captured by some of the views of the career staff that, hey, we've been doing it this way for the past 10 years, it's got to be right.
Comments? No?
Let me go to the floor.
Why don't we open it up to questions? So, do we have a microphone? Okay, here we go. I think that, yeah.
this question is addressed to Judge Easterbrook. You had mentioned earlier about transparency making antitrust conspiracies more amenable. And I just was wondering if you could address the contrast, for instance, of the airline industry, where there are very few major players, but the pricing data is immediately available, courtesy of the internet, compared to, say, the consumer healthcare market, where prices are inscrutable, but there are literally hundreds of thousands of players. And what your thoughts might be as to transparency in those instances and how that affects competitive conduct among the players.
I can't talk about particular industries in the abstract. I know that there are data suggesting that the airline industry, precisely because of both the publication of its prices and because of the way in which a hub and spoke system gives economic power at the places where the hubs are, has been thought to be more likely to be able to raise its prices. And you see dramatic changes in price in that industry when a new low-cost competitor comes in. Sometimes it's very difficult to do anything about public prices and about the role as a cartel-inducing device. And airline industry is probably one of those where you couldn't make the prices secret without making it very difficult for people to buy the product. But there are lots of industries where secrecy is both achievable and beneficial. I mean, that's part of the point that I was trying to get across.
Thank you. Well, the first panel that I went to this morning was very concerned about the role of the administrative state based on the fact that it was not democratically grounded, and also the fact that there is an inherent bias perceived, both observed and theoretical, in the way government officials make decisions, and this was mildly offset by notice and comment exposure to the public for rulemaking. Now, it sounds as if Judge Easterbrook is, in fact, expressing confidence in the ability of government officials in the administrative state to make good decisions if they are given space and removed from exposure to the public, which comes in the form of interest groups. And it seems to me that these two ideas are in conflict with each other. I may have not understood what you said, Judge Easterbrook, but I also have to take this in the context of public choice theory, which I think indicates that the government officials, those making the decision in whatever agency, they are their own interest group. And they will have a certain predilection to decide which will, in fact, govern that decision-making authority even more if they are somehow removed from their agent, from the interest group politics. So not looking, as you suggested, not looking at the question of transparency, but I'm intrigued by your comment about trying to remove these officials from factions. I'm not sure that's the way James Madison thought it would play out, that he thought that two factions were responsible for balancing each other in the debate.
This is probably not the place to have a full explication of Madison's theory of government. But it was important to his theory that public officials be protected in part from faction in a variety of ways. One was indirect representation. Instead of having direct democracy, we have an indirect representative system. Madison and his colleagues arranged for different centers of power with different electoral bases and different times in office. And the idea was that power would be set up against power. you don't rely on everybody being an angel, but you rely on some insulation from factions and some opposing centers of power within the government. The concern about transparency that I was expressing was that transparency in enforcement is often understood as a program of exposing the decision directly to factions in the way that the Administrative Procedure Act exposes regulation directly to factions, as if this whole Madisonian process were to be bypassed. I think the Madisonian process is by and large a good one, which should be implemented rather than our trying to find a way to bypass it.
Let me add a thought or two. It's a bit ironic.
Yeah, this is no.
It's a bit ironic in a way to hear the notion that we have to worry about the administrative state because it's not democratic enough in the context of an antitrust discussion when some of the leading challengers to the consumer welfare standard and the inheritance in a sense from then Professor and then Judge Borg is that, well, it has led to an antitrust that is not democratic because it's in the hands of technocrats. I'm a big believer in technocrats and I guess a Republican form of government rather than a Democratic one because there are useful roles for people with superior expertise. But I just wanted to say one thing about antitrust in this larger conversation. It is the antitrust agencies, even the FTC, although there's some roughness around the edge, are not regulators. They're not part of the administrative state. They're part of the law enforcement apparatus, and ultimately, they can't do anything unless the parties expect that they will get, or they do get, the blessing of an independent Article III court. So that's an enormously valuable check, both on the public choice problems and on the lack of, and on the sort of the broader administrative state non-democratic problem.
If I could say a bit in opposition to that, the Federal Trade Commission Act gives the Commission the power to define unfair methods of competition. That's actually a regulatory power. It's often used in connection with the consumer protection side, but it can be and has been used in connection with the antitrust side. And when the FTC exercises its regulatory power, a court is going to say something like, well, they're a political agency, they've made their decision, unless they've taken leave of their senses, it's going to be enforced.
I'm sorry. That's all true in a way, except the last empirical proposition. While the FTC has not passed rules, and that may change the game, expanding the notion of unfair competition beyond the bounds of the Sherman Act, it has tried to do that by adjudication. And it's lost almost every case. Because the courts have basically said, you don't have a coherent theory for justifying an interpretation of anti-competitive, unfair competition that goes beyond the antitrust principles, and indeed have said, and whatever it is, it must include injury to competition within the meaning of the Sherman Act. So that's what I meant by the roughness around the edges of the FTC, but I just think it's a much less serious problem than perhaps Judge Easterbrook's comments might have suggested.
Good afternoon. Dan McInnes. I have a question going back to the AT&T case. So this year, the Antitrust Division tried and lost the first vertical merger case that's been litigated in 30 years. There's now a rumor that the Antitrust Division is thinking about issuing new vertical merger guidelines. I suspect a lot of people in this room have a healthy skepticism of the federal government and a healthy skepticism of federal regulators interpreting their own rules. Why shouldn't we have a healthy skepticism, even in this administration, of the Antitrust Division, in this context, issuing new rules for vertical mergers, where we have a court that interpreted the law in the DC Circuit who is now hearing that case on appeal?
I have to bow out. The rules of ethics applicable to judges say I can't say anything about something that's in litigation. So everybody else can talk, I can't.
Is it a statement, Dan, or is it a question?
It's a question. I mean, why should we support new vertical merger guidelines at this particular time? Aren't we better off with speeches, cases, interpretations, rather than policy guidelines that, frankly, at least in my view, get overinterpreted by courts as statements of law rather than simply just policy statements?
But, so whether it's guidelines or something, a document called guidelines that explains how they look at things, or it's a statement, or it's a speech, it's all an explanation of what you're doing, right? So and to Judge Easterbrook's point, we're talking about transparency as a label, but it covers a lot of different things. And you can go look at the specific things if you look at the ICN and OECD and the policy framework. But the idea is that what you don't want is a U.S. Justice Department challenging the AT&T merger case or challenging any other merger case on a whim, as a matter of capriciousness. What we don't want is to have a Justice Department challenging transactions in a situation where we don't know why, right? We don't know the basis. We don't, where you can interpret it potentially as a political move rather than as a law enforcement move. So whether it's guidelines or anything else, I think to me it still makes the case for transparency. And while it's true that ultimately the Justice Department or the Federal Trade Commission has to go to a court of law to stop a transaction, the AT&T case is a very unusual case in the sense that most companies do not have the luxury of going to court, or they can't go to court, right? Because you can't, I don't remember exactly the timeline, but it's not frequent that you can actually sustain a transaction through the investigation under the Hart-Scott-Rodino Act and through a court trial. So as a practical matter, most companies, frankly, are not going to get their day in court on a transaction. So therefore, I think what you really would rather have as a company and as a counselor is for the agencies to put out in advance at least, here's how we're going to look at things, so that you don't necessarily have to wait to get to a court of law a year and a half after you announce your transaction. But you can actually, you can argue to the guidelines. You know what their evidentiary standards are, so you marshal the evidence. So you're much better able to deal with getting your transaction cleared, it seems to me, if you know what the procedural rules are and you know what the substantive rules are. What I would fear is the case is, imagine that we didn't value transparency whatsoever. Then nobody would know whether the merger was going to get through, if the merger didn't get through, why it didn't get through. No one would be able to plan for a transaction. No one would be able to allocate risk. No one would be able to invest freely, understanding what the rules were. In this day and age, in this administration, people would be claiming that every single thing that the Antitrust Division did, as they did in the AT&T, was politically motivated. You can't have, in my view, an effective legal regime if nobody has confidence in what they're doing and what people are doing. If nobody has confidence that you've got standards that you're abiding by, whether or not people agree with the standards, if nobody has confidence that you're applying the law impartially, if nobody has confidence that parties are going to know what the target is in an answer, you're not going to have any confidence at all in that legal regime. And I think that's a problem. I think that's a problem for larger society. You might say, well, I don't really care about antitrust law, so who cares? Maybe, we won't have antitrust enforcement. But it's part of the rule of law to me, and it's part of our faith in our institutions. And so I won't be back down to saying that transparency is not a laudable goal, including in this country.
I'll just briefly agree with Deb's point that she made earlier, that, had guidelines been in place, that would have helped the division deflect the perception that the challenge of the AT&T merger was politically motivated, but I think my agreement stops there, because when you put that kind of more maybe prudential concern aside and go to the merits, I share your very healthy and well-founded skepticism that if vertical merger guidelines were written right now, they would be written with the overriding goal of giving the Antitrust Division a thumb on the scale in its next challenge and an ability to cite those guidelines to a federal judge as to why the division should be prevailing in the action. So I'm very concerned with, the content of those guidelines. The existence of them would to me, certainly address the concern that you said before, but the content of those guidelines, I don't have any confidence that would be written in a way, kind of, to be fair to your earlier comment about things that would bind the agency going forward. I want my agency to want to be bound going forward to fair rules of the road. I don't want my agency to think, well, I don't want to write something that's going to, kind of tie my hands in the next case if I want to do that. I want my prosecutors to put rules out there that say, yeah, these are the rules of the road, and I'm going to follow them, even if it's not something that's going to help me win the next case.
And Eric, to your point, if to the extent it's a problem now, and difficult for them now to put out vertical guidelines because people will be suspicious or cynical about what they're doing, all the more reason for them to have done it before, for not to have had guidelines that were irrelevant for so many years, from 1984. And I think that the reason that we didn't see guidelines previously is because the agencies didn't want to be bound. It's hard for an agency to put out guidelines, to be honest. I've been there before when we've done a lot of guidelines. And and it's always been, believe me, it's never been the career staff that wanted guidelines. God forbid. It's always been the political leadership that has said we want guidelines. Why is that? Because the political leadership understood the importance of accountability and the importance of the process that you go through when you look at guidelines, because it exposes your precepts. It exposes you to criticism before you set your guidance out. So the guidelines have always been motivated by political leadership that felt it was an important part. It's never been, the career staff has never seen guidelines as being helpful, a helpmate to them in bringing cases. I do think the other thing about vertical guidelines, even if they do them now, there is a culture internationally of putting guidelines out for comment. So anything that the Justice Department or the Justice Department and the Federal Trade Commission would put out now would be subject to robust review and criticism, which is also good because that continues the debate and the questioning about the validity of the guidelines themselves.
My very first antitrust case was the first time that Staples tried to buy Office Depot back in 1997. And back then, merger challenges were not litigated very often, and we litigated that challenge, and we lost. What happened during the pendency of the investigation and second request and all that leading up to the DOJ's enforcement challenge in court was they revised the guidelines in 1997 to change the description of the efficiencies defense that we had been pursuing. So they changed the guidelines specifically in response to the dialogue that we were having before the case was brought, and they changed it for their advantage.
Let me just add, if I can, very briefly. I agree with everything that Deb Garza said. Her last point about the tension between the political or senior folks who want guidelines and the staff that always says, don't tie our hands, is very real and very illuminating. And I think we have to distinguish two very different questions. Do we agree with the guidelines, and do we think that they are the product of an honest, serious, good faith effort to promulgate standards that can inform a prudent government policy attempting as best human beings can do to serve the public interest? In my experience, the guidelines are, if not uniformly, almost always fall into the second category. Certainly the horizontal guidelines, with whatever changes Eric had in mind, have been an enormous contribution for all the agency constraining and signal giving reasons Deb talked about, and also because they have educated a large community about how to think about horizontal mergers. I don't doubt that if the agencies could come up with vertical merger guidelines, which would require some kind of a consensus among the people who are there, across disciplines, the economists and the lawyers and across agencies, that they would be a big plus, not only in terms of the institutional considerations Deb was talking about, but in terms of advancing a shared understanding of some of the issues that need to be addressed when we think about vertical mergers, even though I am certain I would not agree with every part of them. I don't think that's the test of whether guidelines are desirable or not.
Do we have any more questions? We've got one more in the back.
Hi, I'm Bob Popper from Judicial Watch, and it's at least been implied a couple of times in this panel that a belief in transparency is typically held by people who do not share a belief in the classic consumer welfare model of antitrust. And so I wanted to ask the two practicing lawyers from the big firms whether they would describe themselves as individuals who do not believe or who have serious criticisms or questions about the classic consumer welfare model of antitrust, and whether they believe the EU does.
You want to go first?
Well, I testified in the FTC hearings in favor of the consumer welfare standard. Although I do agree with Doug Melamed that some people sort of caricature it in order to knock it down. I think it has some flexibility, and I don't agree with the criticism that it's focused solely on price and static competition. But I do believe in the consumer welfare standard, and I do agree that there are limits to antitrust, and I don't agree that antitrust is the cure-all for everything. I agree with Judge Easterbrook on his concerns about the expansion of antitrust. It's not, antitrust law was never meant to cure income disparity or any, anything else like that. So yes, in Europe, I know that, just having come back from an ICN merger workshop in Tokyo, I know that outside the U.S., inside the U.S., but also outside the U.S., I know that there is a lot of sentiment for expanding the standard. There's a feeling that the consumer welfare standard is too inhibiting. There is a real concern in parts of Europe that they really want to use competition law to get at a lot of perceived ills, which is, to me, I think, a concern. And that's why I think transparency is also important. Because there are people over there who would use the antitrust laws to enforce some paternalistic standard of what privacy should be, or to deal with income inequality, or to deal with a lot of other things that I don't think the antitrust laws are well fit to serve. And again, going back to the theme of the panel, the transparency that we've brought about over the last few years is good because we know that's happening. I think it's important to understand and to have people discussing those things and have them be the subject of debate and testing, because I'm concerned that if we didn't have that kind of culture, what you would have is decision-making that was tainted by not just fuzzy thinking and not by bias, but by, concerns that had nothing to do with antitrust. And we will see that creeping in, I think, if we start to allow enforcers to operate in the shadows.
I agree with all of that, and I just, I don't think we should be apologetic about it at all. I guess I would say that, when I hear comments like, well, the consumer welfare standard, has some flexibility to it. But flexibility for what? Because the Sherman Act is not concerned with whether people will lose their jobs. The Sherman Act is not concerned with data privacy or anything like that. The Sherman Act is concerned with whether the certain proposed transaction will make things better or worse for consumers. And that's not just prices. That might be things like choices or the ability to innovate. So it's not, singularly focused on price. There's all kinds of elements of consumer welfare, quality, quality of the product. But if anyone ever suggests to me that it's an appropriate consideration in a merger review to consider whether people are going to lose their jobs or not, I'm going to tell that person that they're absolutely wrong. And luckily in the United States, I think there's enough of a sort of settled, established view in courts that that view would not hold any sway to the questioner. To the extent that argument were made somewhere else, like in Europe, then I think there's a little more potential for it to have traction because they don't have 100 years of the traditions that we have. So, and by the way, I'm completely in favor of transparency. So,
I think with that, we are concluded, and I'd like to thank our panelists.